Members of the committee, good evening. My name is Horace Small, and I am the executive director of an organization called the Union of Minority Neighborhoods. We're based in Jamaica, in the Jamaica Plains section of Boston. What makes it significant for me to be here today was that it was my organization that for 7 years led the fight for criminal justice reform in Massachusetts through the Mass Alliance to Reform CORI, getting legislation through. It took 7 years for a lot of reasons. It took 7 years because of misinformation and bad ideas. Misinformation such as, what's a good one? Well, if we give people second chances, they will go into neighborhoods and terrorize people. Well, I mean, there's not too many black guys from Mattapan who are going to go to Wellesley, to commit crime. That didn't happen. The other line that was told was that if we take people with criminal records, they'll go into companies and they're violent and kill people and hurt people. Well, that didn't happen either. So, and we also were told that if people with criminal records, if we reform criminal justice reform, prison guards union might have to lay off people. Well, all that didn't happen either. What's clear for all of us is that, and I speak today on behalf of the hundreds of thousands of people who were impacted and were affected by criminal justice, by CORI reform, by CORI, very simply is that this is an absolutely bad idea. The reason why we fought for CORI reform was because people wanted second chances. They made mistakes in their lives. They wanted second chances. They wanted to go forward. They wanted to get educated. They wanted to raise their family. They wanted to be productive. They wanted to pay taxes. That's why we fought for criminal justice reform. And this, putting this online, one of the things we absolutely do know is that when you put these things online, you can't take those things back. I remember an email I sent to Tom and Nino, which I wish I hadn't sent. I didn't mean to send it, but it kind of went out anyway, and I couldn't take it back. So, and that's the dilemma with putting things online. So we learned early on that CORI reform was not just it wasn't a racial issue because, there's 3 million people with CORIs, and that's an awful lot of white folks who have criminal records. So it wasn't a race issue, but it damn sure was a class issue. And this too, again, is a class issue as well. For those of us who care deeply, who want to continue with their lives, who want to work to make their communities better, who want to be contributing factors in their community, this is absolutely, absolutely a very, very bad idea. As the sister who spoke before me said that lots of people could get access to records. Children could get access to records. Families could get access to records. This is it would be debilitating and destroy the lives of individuals. We ask you, on behalf of hundreds of thousands of people who are affected by CORI in the Commonwealth of Massachusetts, to really, really think about this and to, in the words of Nancy Reagan, just say no. This is a really bad idea for them because this would defeat everything that folks fought for 7 years. And on that note, thank you, and Small, not Smith. I'm glad you got it.
Thank you very much. Thank you. My glasses again. Grace Marie Thomaselli.
I solved the problem. My sister and I, she's the next person on. Would it be all right if we're both here together so that we can save time?
Sure.
Okay. Do you want to call her up or?
Joyce Thomaselli.
Thank you. I'm honored to have an opportunity to be here today. I've seen your names many times. No one wants to be a pro se litigant. And it's not easy being a pro se litigant. And it's not easy being in the court system, even when you have an attorney. The hours are incredible. And you don't go there unless you look for justice. And you come to the court system for that. And my sister and I, since 1995, 20 years, we have been seeking justice. And the more we sought justice, in every court. All we had to do was have the other side, which was the town of Salisbury and their attorneys, Copeland and Page and Coppola. All they had to do was lie to every judge. And because they were so powerful, because municipalities are considered credible, and naturally, Copeland and Page is considered credible. So what does that make us? That we're not credible? However, I'm grateful that we had the EPA and the state support us and get documentation. My sister, I have to commend her. She spent months going through EPA and state documents. The town of Salisbury actually told the court that an $18 million sewer project that was 100% grant funded, they said it was $80 million under oath, and said they got 90% in grant funds, which is $72 million. Thank God I had the EPA who said, what are they kidding? Do they know how much $80 million was in the 80s? And we lost at the appellate tax board, but we were the ones telling the truth. So we went to the appeals court. Again, the lies continued, and the more they won, the more we lost. We went to the Supreme Judicial Court, federal court. When we spoke up at meetings, they called us out of the meetings and they put it on the internet. 2 sisters escorted. We weren't escorted because we were troublesome. We were trying to get answers. So what happens now is the more we lost and the more they won, the more credible they became in every court, even in the federal bankruptcy court, federal court, First Circuit Court of Appeals. We went as far as the United States Supreme Court. I don't know how many attorneys have written a petition for a writ of certiorari, but my sister wrote 2 of them, and she's not an attorney, and neither am I. No one does this if you're not looking for justice. So the reason I'm saying this is it's true. You can pick up the internet and you can look at the findings of fact and report. The facts were not facts at all. I looked at Judge Piper's decision. He used the wrong dates. He used the wrong amounts. He used everything that the town of Salisbury gave. Didn't use not one document from the EPA, even after we asked for a motion for reconsideration to please include the truth. So, Your Honor, you can make a decision. I don't want to be in court. We had a beautiful Italian restaurant. As Kevin Cullen said from the Boston Globe, one day my sister said, I don't want to be writing motions. I really want to be serving linguine. And you know, it's true. All we wanted was our little Italian restaurant that the town of Salisbury took away from us. And now we've lost our home, a foreclosure. I'm in the land court, and I'm actually in one of your courts now too. We're in the appeals court. We have to find justice somewhere. So please, when you put information online for people to access, let's make sure it's the truth. It's the truth we need out there, not the findings of fact that somebody wrote in. That's not the truth. And there's another thing that's very important. You know, credible is a very scary word. There are many very powerful people in this world who are credible, but they're not truthful. And we did say that to the court. I know someday I will get justice from one of these courts. I really believe that we will, and I'm looking to you all to please look for the truth. Procedure is great, but why is it that we have 30 days to do something, but it took a judge almost 3 years to make a decision while we're accruing 16% interest? Why was my wrong bill that went into the land court that was under $50,000, and that was the wrong bill, why is it over $250,000 today? Why? While I've been waiting for the truth. So please, You're very powerful people. You can do a lot of good and you can do a lot of harm. Please be careful and think about the people who are coming to you as pro se litigants. They're not coming to you because they're troublesome. They're coming to you for help. So please remember that. Thank you.
Thank you.
Hello, I'm Joyce Thomaselli. As Grace Marie just said, I want to thank you for this opportunity. I advocate for transparency in government, and I have been seeking justice for very many years through the court system. There are some issues I'd like to bring forward. So, one thing is copies at $1 a page is excessive, and it's prohibitive if you're copying a case file. Many of us just cannot afford this cost. Another thing, please have the courts record all hearings, including sidebar, and have a CD available at a nominal fee. My experience is the first judge made a decision at sidebar, but I didn't know this. He made a decision regarding an assessment date, making me and my sister liable for an assessment. This decision was wrong, and it was based on the town of Salisbury's fraudulent representation. This has caused us 15 to 20 years of litigation, and I have never been able to correct this error. You see, because once a finding is made, it becomes a fact. Even though it was based on fraudulent information, because this decision, what they spoke about, wasn't recorded, I have no access to the discussion that went on in sidebar, and this should be a public record of the entire court proceeding. Please allow parties to videotape all hearings, including sidebar. The transcript, to create a public hearing, a public record of the hearing, the cost is prohibitive for many of us. Example, it was $7,000 for a 2-week trial in the year 2000. I could not afford this charge. I never received the transcript. If I would have had a hearing recorded, I would have had access to a CD, and all I wanted to hear was the truth of what was spoken. This system of only transcribing a court proceeding is archaic. And it's archaic, thank you. And what happens is we have no access to what was truly said at a hearing. Not all transcribers do accurate work, and many of them use dashes to replace the words that were spoken. So even though you do an errata sheet, you know what, you never really have a true record of what transpired. Another thing, pro se litigants need access to dockets and documents online. Example, I didn't know the appellate tax board made a docketing error by not docketing a hearing. Being pro se, I had no access to the dockets online. So on our appeal, I referenced this hearing in my brief. The Salisbury Town Council, who attended the hearing, wrote in the town's red brief that we were not being truthful because the hearing was not listed on the docket. I was so upset to receive this from the town. I contacted the appellate tax board, and they quickly corrected the docket and provided it to me with the corrected docket information so I could submit it with my reply brief to the appeals court. So the importance of having litigants access to docket sheet, I would have known that there was an error. I understand I believe it was a true error on the court side, but because they made this error and I didn't know, I was written that I was lying to the court, and I wasn't. Please allow pro se litigants to file motions, etc. by fax or email in every court. And lastly, but very important, because of my experience, my very difficult experiences, please, judges, please do not make written decisions such as a matter of law. The case is denied. The case is allowed. Every decision should have a reason, and it should have the applicable law, the statute. a written reason that becomes a public record so that people have an opportunity to appeal it if the decision is an error. When you have a decision saying a matter of law, I spent years going, what law? What did this mean? I never was able to find out the law. It's just horrible to have a decision rendered in that way, and also have appeal rights written on the decision. So this would give the party enough information to seek review and a remedy. I thank you so very, very much for your time.
Thank you both very much. Norma Wassel.
Thank you so much.
Okay.
My name is Norma Wassel, and I'm a licensed social worker, and I also am a founder and current chair of the steering committee of the Massachusetts Bail Fund. And I want to talk specifically around the issue of data that needs to be available for groups such as ourselves who are working on public advocacy and actually impact state public policy. I want to give you a couple examples of how the lack of data, access to data, the lack of standardization impacts not only groups like ourselves, but people who are actually working on behalf of the state. Even legislators can't get this information. So why did we found a bail fund? Social workers, defense attorneys, community advocates were working and seeing clients being held on low bail across the state, $50 to $500. We founded a bail fund where we post bail for people on bail under $500. This is happening throughout the Commonwealth, and it's still continuing. We get more referrals than we can handle. We post bail, we operate a revolving bail fund, and also because we are seeing systemic problems throughout the pretrial bail process, we also looked at doing advocacy work. And some of this has resulted in actually a filing of a bill that people may know about, Representative Santacandro and Senator Donnelly, who have filed a bill on the Act for a pretrial process to look at bail reform that other states have implemented, including doing away without cash bail, so that the amount of money you have doesn't impact the justice that you get in this Commonwealth. I specifically want to talk about our advocating for access to court information for the public, having open records, particularly in the pretrial bail process, and using this as an example of other groups throughout the state who are working on public advocacy areas, whether it be environmental, whether it be a relationship to housing, of needing this information to inform us and in turn help educate our legislators and people in public policy roles. They often look to us, organizations, for this information. So we were seeing people being held currently, our average bail for 2013-2014 is $364. So we have residents throughout the state of Massachusetts are being held on very low bail that you and I could afford, and has significant collateral consequences. They lose their kids, their housing, perhaps are in mental health substance abuse treatment, lose that as a matter of getting into jail even for a couple of days. The other thing that I wanted you to be aware of is the lack of data also keeps systemic barriers still existing. So for example, we physically have to bail someone out, go to the jail in the evening. There's no systemic way that you can go to court unless your client is in court that day and post the bail. So we would like to even have you within your review of looking at the systemic issues that impact the procedures or access to justice in our state. We have also wanted to recommend standardization. We have had major problems getting information even when the Commission on Criminal Justice members, or for example, my state senator, who's Senator Pat Jalen, who's on the Commission for Criminal Justice, they're asking us in our advocacy work to look at, should I just put this down? To actually help them get data because they have also not been successful. So we were wondering, are what we seeing the tip of the iceberg? We're in some counties, but what's happening in New Bedford, Fall River, Holyoke, Worcester, Lawrence, Lowell, areas of extreme poverty. So we're hearing these things anecdotally, and we're asking for data from the Mass Trial Court, but we can't get it. or we get it in bits and pieces, or what we get from one county doesn't match what we're getting from another. This has been documented in a paper that we did, a report with Northeastern Law School on Massachusetts alternatives around the bail system, and also recently by the NIC, National Institute of Correction, report that they did on Middlesex County on analysis of their pretrial defendants population. As you know, Middlesex had a closing of a Cambridge jail. They're looking possibly to build a new one, and they're needing to have data. How many people in their current jail at Billerica is housing people on low bail? Nobody could provide that information to them except the snapshot that they did under Sheriff Katujian's current population. They're estimating as many as 25% of people are held on under $1,000 or less. And we want you to analyze it. I live in Middlesex County. Before you're looking at building a new jail, how do we get the data from the court, from the pretrial, to look at, do we really need a new jail, or are there other alternatives that could be implemented? The other thing that we are seeing is barriers for when individuals are trying to get information. So when we have these lack of data in these reports, that we actually try to show the problems. We, for example, trained a group of 60 volunteers to do a random sample of 30 courts throughout every county in Massachusetts to get information from court dockets, to a 2-week random sample from 2012, to see if what we were seeing was also true throughout the state, because we couldn't get this systemically from the mass trial courts. And we found a total range of response of each courthouse. One courthouse had computer access. Others said come back. One said we're available at 4. Intense labor for the court clerks to give you the information, to give you the actual dockets. So there's no standardization, there's lack of information. We're constantly trying to get the information, had to hand sort through dockets hours and hours and hours. We don't know if the state, for example, might have this information, or it's just not available to us as a public John Q. citizen or Jane Q. citizen, or is it kept in any way? We'd like to make recommendations that be kept. So if you're looking at open access, please think of the impact this information has on public policy and saving money. So we now currently have made public access record requests to a range of areas in the court system, and the responses vary from, sorry, we're not covered under the Mass Public Records Law, to here's some information, which is very, very helpful, and it's going to be used to inform our work in terms of the work we're doing with public officials around reducing the cost of detaining people on very, very low bail, nonviolent crimes that don't need to be incarcerated, or largely there due to substance abuse problems or mental health issues or other areas. So we wanted to make sure that you look at the systemic changes you could put in place that systematize information, and you look at how the open access would impact and inform us around public policy. Thanks very much.
Thank you very much.
Is there anything that you want to add?
Alexander Jones? Is he?
He's with us.
Yep.
Thank you, members of the committee. I understand I'm out of alphabetical order. Currently, I work for the Massachusetts Bail Fund. I'm also a first-year law student, or a rising second-year law student at Northeastern University School of Law here in Boston. And I wish to echo what Ms. Wissell was saying and add a few things, because I have been working on trying to get some of the information on the court system, working to no avail mostly. Louis D. Brandeis, the great Justice of the United States Supreme Court, and actually a practitioner here in the Commonwealth, once said that sunshine is said to be the best of disinfectants. And the sunshine in government is public access and citizen involvement. Unfortunately, there's not a whole lot of either in the court system. I've found that when I've tried to access data for the court system, I constantly run into the same brick wall, which is the public records law. And I understand that the Supreme Judicial Court has ruled that the judiciary is not covered by the public records law. I understand that. I understand the statute does not cover the judiciary. I understand that. However, I do not understand why some offices will give me information and other offices in the Department of the Trial Court will not. That doesn't make sense. As Ms. Wassell said, there needs to be standardization not only of the data that goes into the trial system and comes out of the Department of the Trial Court, but also policies. It's all well and good to have a uniform policy on no access, but it's also problematic to have a disparate set of policies of access to some records and no access for others. This leads to confusion, this leads to frustration, and this also leads to clouding of the sunshine that needs to go into government to make sure that it's running well. Louis D. Brandeis also said that the most important office in a democracy is that of the citizen. It is not the president, it is not a judge, it is not a senator, it is the citizen. And the citizen cannot perform their duty and cannot discharge the duties of their office if they have no information. There is no sunshine in the darkness. Jesus of Nazareth said, "You do not put a light under a pillow, you let it shine out in the darkness." So let's have a little bit more light. I understand that the judiciary is not covered by the public records law, but that does not mean that people can still not get information. You can have your own policies set forth to allow for individual offices to allow people to come in and get records, or to provide small amounts of information so that people can have a taste of what is in the records. And last but not least, I ask that you urge the Supreme Judicial Court and the legislature to amend the law as it stands, whereby the judiciary is not included in the public records law. Thank you for your time.
Thank you very much. Let's see, Brooke Williams, William, I apologize.
Hi, my name is Jennifer McKim. I'm not Brooke
You
Williams.
don't look like Brooke Williams.
But
Are you speaking for both
I am
of you, or-
speaking, yes, she and I are both colleagues at the New England Center for Investigative Reporting. She was not able to come today, but I am also a senior investigative reporter at the New England Center, which is a nonprofit news center based out of WGBH Public Radio and Boston University. I've been a reporter for more than 25 years before I came to NECIR. I worked at the Boston Globe and also at the Orange County Register in Southern California. Court records are a key tool for watchdog reporters to use in telling stories that make a difference, prompt legislative changes for good, and focus public scrutiny on systemic flaws and bad actors. I'm continually surprised at how difficult it is to access public records in the state of Massachusetts, in particular in the convoluted court system. Particularly, I was dismayed to find that the court had started to reduce the public access to superior court records. Indeed, we believe the court should not only not limit them, but expand records to provide full text of these records. I wonder why attorneys should have easier access to such information that is not available to the rest of the public. Already, we've used the limited access in superior and district court documents to write important stories that affect marginalized people in the Commonwealth, including, most recently, a story I wrote on people who lost their homes to foreclosure and were being pursued by debt collectors for financial losses they'd never be able to cover. We also use land court records to document a growth in foreclosure filings from third-party investors, who increasingly are buying up tax liens from cities and towns, an issue that housing advocates say is affecting a growing number of elderly and disabled residents. Without publicly available court information, our ability to do our work, serving as the eyes and ears of the community, is seriously curtailed. Already, I spend countless hours driving through to local courthouses to get court information that would be publicly available at our desks in other states. In addition to time and transportation costs, we generally are asked to pay $1 a page for these records at the courthouses. And one other thing I was thinking about as I was sitting here is I've also spent a lot of time and energy getting court transcriptions from the courthouses, which is also a confused process of tracking down court recorders to tell us where the information is. We at the New England Center for Investigative Reporting urge you to expand both free and public access to court records. Thank you.
Thank you very much. I believe that concludes our list of registered speakers for the evening. Let me, on behalf of the committee, thank everyone who has come today, everyone who has submitted verbal comments and written remarks. We've received a wide variety of views and approaches to the difficult issues that confront us relating to public access to court records. We intend to read, to review, and to consider all comments, both those made here today and those in writing. And we will continue to work to develop a set of proposed rules to govern access to public access to court records. As I indicated at the outset, our plan and hope is to draft or complete drafting a proposed set of rules which will then be given to the Chief Justice of the trial court to then be posted for public comment. There'll be a period for public comment for everyone. You can send in additional comments at that time. We'll receive those during the comment period. We'll work toward a final set of proposed rules, and then our work will be sent to the Supreme Judicial Court, who will have the final determination and consideration of what rules will come forward on public access to court records. Today's proceedings we anticipate will be compiled in some kind of either transcript or electronic form or both, and we do expect to be able to make that public to everyone at some point. If you check the trial court website, we'll give you further information as soon as that is all compiled. So thank you all very much for coming.